Please avoid it. And possibly we think we have to interest as a mediator, we have to protect the interest of both parties and the lawyer's interest also. So for which the executability is very important. If the agreement is not in executable manner, the parties will suffer. There is no provision for appeal. There is no provision for second round of litigation. So, as Order 23 Rule 3, you know, we are drafting as per the provisions of CPC Order 23 Rule 3. So, if it is settled, if this decree is passed, no, nothing can be done. So, please understand, when we are drafting settlement agreement, we are sure that if you have any doubt, please ask the seniors. Senior lawyers are there, senior mediators are there, senior persons are there. You can correct it, and we used to discuss upon even now. So we are all complete. We are not complete persons. We are all incomplete. So just please understand, please ask the others and correct it. And a better executable agreement must be there. Declaration in drum, not possible. Declaration in person is possible to settle. So there is a specific Leave Act, Contract Act, and Transfer Property Act, CPC, the relevant provisions of procedures. So very important. So otherwise, if there is seen any defect, the judicial officers we have yesterday, it is that we have discussed with them, that we have told them that return back such agreements to the mediator concerned. Then again that have to be corrected. So my friend will add something. Let's please, Dhananjay.
My friend has already covered the main points. What I want to tell you is that we are all familiar with Order 23 Rule. We are all lawyers. So whenever you are preparing a petition under Order 23 Rule 3, you know that how to prepare it. And whenever you are preparing a mediation agreement, it must be in your mind. You are preparing a mediation agreement under Order 23 Rule. If a petition is drafted, ill-drafted under Order 23 Rule 3, we won't get a good decree. So that some lawyers may not be actively practicing, some mediator lawyers may not be actively practicing civil court. So, if we are those mediators who are actively participating in criminal courts, they may not be knowing the nuances of Order 23 Rule 3. So, they should seek the advice of the civil lawyers. That is one thing. And another thing is that you seek the help of the lawyers as well. Both lawyers are there. So they are, because the lawyers has to protect the interests of the parties. So with the help of the lawyers, you can prepare a good, valid, executable agreement that you can do it. So don't do it in a lighter way. Because as a lawyer, you are not preparing Order 23 Rule 3 petition in a lighter way. You are in a very serious way you are doing it. So don't think that it is a big thing or a difficult task preparing mediation agreement. But only thing is that when you are preparing agreement in criminal court, suppose you want to file an agreement in criminal court, we know that criminal court cannot pass any decree. Only then and there settlement is there. If it is compoundable offense, no problem. Absolutely no problem. You can draft the agreement and send it to the court. The court will, based on the basis of the agreement, the court can acquit the accused. But if it is not compoundable offense, then the problem is there. You cannot write an agreement. We settle the matter and the accused may be acquitted in non-compoundable offense. It is not possible. Only under 482 or some other way we are doing it. Maybe we would say that matter is settled, parties would take appropriate action to see that the accused is acquitted. We cannot say that matter is on the basis the accused shall be acquitted on the basis of this mediation agreement. That's not possible. Once the mediation agreement has come to the court, some lawyers would do that. We put the parties in the box and they will demonstrate. That is what we are doing. That report will be there. We cannot say that it is an agreement. Report will be there. Or they will seek some time, 1 or 2 months time. The court will generously grant time. By that time, they will go to take up the matter. I go to see that the matter is quashed. So that is matter is there and still matter. So these are the ways we should see whenever the matter is settled. And whenever, suppose a rent control matter has come to you, how to settle, how to write the mediation agreement. We should specifically mention accepting the bona fide need of the parties. Then only in such a way you have to draft the agreement. So that every agreement you should very careful how to prepare it. These are things in our mind. Because if the agreement is ill drafted, it will create a lot of problem in future. And we have faced a lot of problem in Kerala. And Kerala and High Court, our High Court has given a direction to us to give a training, extra training for mediators only on how to draft mediation agreement. Unfortunately, in our curriculum, there is no topic for mediation agreement. There is no topic for mediation agreement. So what we are doing wherever we are going, what we are doing last day, because there is a topic for showing documentary. One showing documentary. That curriculum was prepared 8 years back. During that time, there was no such mediation. People are not aware about it. Advocates are not aware about mediation. Now we have seen a lot of mediation. So we need not see any mediation drama or some document. We need not see that thing. That's why we are utilizing that time, and that's why today we took 2 hours. My friend has taken more than 2 hours for this drafting of mediation agreement. Such a we can do it. So we are thinking that we will be requesting MCPC to include, because tomorrow after the Mediation Act is notified, no one will be there. There won't be any perusal of the court. Once the mediation agreement is drafted and submitted before the court state that mediation agreement is in the court. Now decree need to be passed on the basis of the mediation agreement tomorrow. Now the court is going through verifying the document. And then the rules is clearly provided that there must be a posting for that. These things are happening. So that it's a very serious thing, but don't be afraid of that, because you are all seasoned lawyers and you are a civil lawyer. Many of us civil lawyers. You know it very well. You can do it. Okay?
Thank you, sir.
My only suggestion is that there are senior lawyers in our group. Senior madam, the sir is there, madam is here. So they are well versed with the nuances of these provisions. So I think you yourself prepare a group and make a class. One day class you can create different topics in drafting agreement. Drafting agreement is important. So you can give awareness in between. Means when we are doing training, we also learners. So not as a teacher, we as a learner, you can create a group and fix a day and take a class on conduct a class in the drafting of settlement agreement. So settlement agreement is actually different because the process nobody will know. That in morning session I have explained it. Nobody knows about the process because this is the confidential. The party and the mediator alone can understand what is going on through the process. But the agreement is not like that. It is a document. It can be perused by somebody else. We are bound to give copy also. If we prepare the agreement, we have to give the copy to the parties because it is their document. So if this copy they are taking, they will go to take the matter before to any lawyer. Nowadays, everybody is connected with any lawyer. So we don't think, we will never think that he is a layman. He will not have any connection with any other prudent person. So we don't think like that. So there will be some connection, some more other way. So if that lawyer is much more well-versed person, he sees this document, immediately he will say, who drafted it? Who drafted this document? So you will not get anything from by way of this. So means the entire credibility of that mediator goes. The other lawyers ruined, have gone, and it affects the system as such. So we have to protect the integrity of the system, for which my only request to you all. So we, our senior lawyers means in our group, almost all the persons are well educated, well versed with the provisions. They are very interactive. So much of caliber is they are having. So you can create yourselves. We never, so for we knows, nobody have taken for us any such class. We ourselves created all this. Settlement agreement on everything. This is a decision we have. We ourselves sat in person, collected material, and how which are the provisions affected, how it is affecting, and even judicial officers also we have taken. We are taking classes because of we ourselves improved. So why can't you? So yesterday, so many judicial officers, some judicial officers would say that the executability is very, very difficult. In one case, one judicial officer said that suit is that's some amount is fixed for payment, and 6 months time is granted as per the agreement, and later after 6 months the suit can be dismissed. Is it possible? How it is possible? So that's not possible as such, because if it is dismissed, there will be non-decree. Decree is not available there. So what can be done? Let it be decreed. Suit can be decreed in terms of settlement agreement. What are the terms? 6 months time granted. If the defendant is failed to pay this amount within 6 months, so there's a default clause. So and so amount to be given. So and so amount. Suppose the plain amount may be 10 lakhs. Suppose accepted. Take it. Then 5 lakhs we are settled. So what we have today, how you will draft it? The plain defendant should accept. Defendant should accept that that's 10 lakh rupees. That is the plain amount is accepted by me. Agreed. But for the sake of settlement, we have agreed. We are both parties have agreed here. They agreed to pay 5 lakhs. So in default, time is granted. In default, full and final settlement. In default, if it is committed, interest without interest, without any further interest or cost, we are ready to pay within 3 months this 5 lakh rupees towards full and final settlement, entire plain claim. This is the word used. So if it is the defendant failed to pay, what we will write? Default clause. Wow. Then it will not be the 5 lakh. Entitled the plain claim. For which the plain defendant should agree, accept that plain claim. Then only we can write it down.
Those parties hereby agreed with the full and final settlement. In the policy,
In default, this amount this can be done.
Sir, I am inviting Honorable Principal District Judge come Chairman District Legal Service Authority, Visakhapatnam, Sri Sinamchat Raj Garu, as a chief guest to the valedictory function. I am also inviting both the trainers, Sri Nandasen sir and PG Suresh sir, as a guest of honor. I also request all the participants to participate in this program, as well as already trainers to be trainers. Sir, sir, even doubt level అడుగుతున్నారా? అయిందా?
ఇప్పుడు
ప్రత్యేకంగా అగ్రిమెంట్ తయారు చేసేటప్పుడు ఆ డ్రాఫ్టింగ్ ఆఫ్ అగ్రిమెంట్ మీద కొన్ని డౌట్స్ వస్తుంటాయి. కొంచెం అవి ఏమైనా ఉంటే ఇంటరాక్ట్ అవ్వండి సార్. శ్రీనివాసరావు గారు అడిగారా? చేశారా? ఇంకా ఉందా ఏమైనా?
సబ్జెక్ట్ సార్ కేస్ టు కేసు అనమాట. ప్రతిదీ కేస్ టు కేసు ఇబ్బంది వస్తుంది.
ఓకే సార్. మనం ఆల్రెడీ చివరి ఘట్టంలో చేరుకున్నాం కాబట్టి మీరు as a token of respect, as a part of Indian culture, we have to honor our guests. It is our prime duty. As a part of it, I request our principal district judge to honor Mr. Suresh PG with a shawl and a memento on behalf of our district legal service authority.
ఓపెన్ చేస్తున్నాను. ఓపెన్
Thank you, sir. Thank you, sir. I also request our principal district engineer to felicitate Sri Tangasan sir. Thank you, sir. Before responding both the trainers, it is our duty, it is the duty of the participants of all these participants. What
So felicitate Chinese gurus.
Yes.
Yes,
Alagas.
time is the
Yes, ma'am.
felicitation.
Yes. Good evening to the all. First day I attend this session by 4 p.m. because I know very lately this information. What happened before 12 noon, I don't know. In these 5 days training class sessions, we know so much of information we are gathered from the well trainers of this mediation program, and also we know the how we manage our professional life and also our family life, how we face the sometimes we face some difficult situations. In that situation, how we face how we manage the situations, they are told very well, and also how the people we gather with some third parties, how we maintain our body language as well as our communication skills, and as well as our our dress sense. We know the so much of information by the trainers. Thank you, sir.
Good.
But Madam and Sir expressed their opinion about their teaching and techniques. But what we have learned,
Oh,
that's the co-surprise. We need co-surprise. Anyone, please, sir. From the day 1 up to day 5, subject wise, what they
taught
teach
us.
taught to you and what you
We
learn.
understand.
Good evening, everybody. Good evening, the dignitaries on the dais and the hospitals. Myself, Muhammad Ishaq. I am a practicing advocate from past 10 years in Visakhapatnam Bar Association. I was eagerly waiting for this kind of session, where recently I have been to the Goa for the mediation ceremony, where our CJ sir said that India is lacking of the mediators. India need 250,000 mediators. But we are having around 28,000 of the mediators that have motivated me. From then, I was eagerly waiting for this kind of section. But immediately when I come back from the Goa, I came to know that that session is being happened with our DLS. For that, I would like to thank a lot the DLSC which is offering this kind of session. And in this session, we have learned a lot of things which can be used for us personally and professionally. The motivation, the communication, and the interaction how we give to the parties, and the ground rules what we need to discuss with the parties, and how the irritated parties can be handled by us by using our soft skills and the communication skills, and how to know about what the party needs from both parties point of view, conducting the individual sections, separate sections. Then we can know what the party needs actually. The needs of the party should be fulfilled. Amicably, we need to resolve the issue, how to resolve the issue amicably. And the gap which is being there for the parties from past prolonged years where the litigation is held in the court and pending in the court, that we need to how we can overcome and resolve the dispute in an amicable manner we have learned. And finally, it will be the win-win situation. Both the parties should win. Amicably, we need to resolve how we can resolve the dispute that we have learned from this training. Thank you, thank you for the trainers and the DLSC which have conducted, and the PDS sir for honoring us. Thank you. Thank you so much.
Thank you, sir. Thank you, sir. There is a difference between negotiations and mediation. Negotiation only 2 persons. Mediation 3 persons. And third person is mediator. Thank you. Amy? Okay, madam.
You can start.
Yes, madam. With the permission of the chair, I handed over the mic to the Madam Lakshmi Ramba.
Yes. Sir, with the permission of DJ Garu, we wish to felicitate our trainees. Yes. Sir, now our training was completed and our lawyers, we the trained lawyers wish to felicitate our respected DJ Garu and Secretary DLSA and our esteemed guest trainees Suresh Garu and Tarkanjar Garu. First of all, now I invite our P. Suresh Garu I invite our Palla Balaji and R. Raju and P. Suresh Balaji Garu and Raju and Rambabu and team. Please come and felicitate our Suresh Garu. Very quick. Please sit. I request please see Devi here. Please all three Devis here. Please come forward and participate in this felicitation. Please come see Devis three. And Saraswati, please you too.
అది కండువా కండువా ఏమో అలాగే ఉంచాలి.
Thank you, sir. Thank you. Thank you, sir. Thank you. Now, I invite our trainer and MCPC member and advocate of Kerala, Championship. Please kindly accept. I invite our Sri Lakshmi, Krishnaveni, Kameshwari, and Pila Binakshi. Please. I'm sorry, I have Venkateshwar, please.
మేడం అది విడదీయకూడదేమో కదా, అది కండువా అలాగే వేయండి.
Yes. Some of make us. Please come on. Please come. Please some male was come forward, please. Then under participate change, please. Side. Please be in order.
కాదు అందరూ ఇలాగా అలా వెనక్కి రండి, మీరందరూ పడ్డారు.
Yes, thank you. So now we request our DJ Garu, please accept our presentation. Chairman, District Legal Service, DJ Garu, please. Sir, please, sir. Who is the trainee, sir? All the trainees are wishing you. Please. Please remaining persons. Ram Rabu and the other person, please come. All the remaining persons, please come forward. Trainees, all the remaining, please. Madam, Manga madam, please come forward. Please, Pramila, is here. Please come forward. All the- Please come forward. Kancha, మీరు కావాలి.
సెక్రటరీ
ప్లీజ్ సార్ కొన్ని అందరికీ అవకాశం ఇద్దామండి. ప్లీజ్ అందరూ పార్టిసిపేట్ చేయండి. రిమైనింగ్ అందరూ